Good afternoon, everyone. I'd like to welcome you to this next event in our speaker series for the 2024-2025 academic year. My name is Kenji Yoshino. I teach constitutional law here at NYU School of Law, and I'm the faculty director of the Meltzer Center for Diversity, Inclusion, and Belonging. For this event, I'm just completely overjoyed to introduce our distinguished guest, Sherrilyn Ifill, whom I'm proud to call my friend. One of the nation's foremost civil rights leaders, Sherrilyn almost needs no introduction. She is a Vernon E. Jordan Jr., Esquire, Endowed Chair in Civil Rights at Howard University School of Law, and served as the president and director counsel of the NAACP Legal Defense Fund from 2013 to 2022. Following her graduation from NYU Law, Sherrilyn began her career at the ACLU before joining the Legal Defense Fund, and she later taught on the faculty at the University of Maryland School of Law. Sherrilyn is the author of the book, On the Courthouse Lawn, Confronting the Legacy of Lynching in the 21st Century, and the forthcoming book, Is This America? She is a recipient of really too many honors to count, but they include being named one of Time Magazine's Women of the Year, Time Magazine's 100 Most Influential People, and the American Lawyer's Attorney of the Year, among many, many other medals and honorary degrees. We're truly honored that she's joined us here today to discuss the future of democracy and civil rights in the United States. Welcome, Sherrilyn.
Thank you, Kenji. I'm so thrilled to be with you.
So my goal today is to have a wide-ranging conversation with you about where we as a country are headed and what challenges we're facing with respect to democracy and civil rights, and how supporters of those values can proceed under the challenging circumstances we're in. I want to emphasize at the outset that our center is a nonpartisan organization. While a lot of today's conversation will focus on the actions of the current administration, I personally would prefer to frame the debate as between pro-DEI and anti-DEI positions, or pro-civil rights versus anti-civil rights positions, rather than as between Republicans and Democrats. I hope the values of civil rights and democracy that we'll be defending in this conversation will resonate with many people across the political spectrum. So toward the end of today's program, I'll open it up for Q&A. Please submit any questions you have through the Q&A button at the bottom of our screen. We'll get to as many questions as we can. So, Sherrilyn, I'm going to begin by giving people a peek behind the curtain, because when we were talking in the virtual green room before we came on today, you asked me how I was, and I said, oh, I'm fine, like this is what we trained for. And you said, absolutely not. This is not what I trained for. So I want to begin with that. We're now just over a month into the second Trump administration. What's your overall assessment of the state of democracy and civil rights in America right now, and where do you think we're headed?
Well, I thank you for the question, because I have really committed myself to kind of radical truth-telling at this period of time. And I think it's very important for us to be unsparingly honest about the perilous situation that we face in this country. I have been eternally optimistic my entire career, always believing that the fight is worth it and that change is just around the corner or just over the hill, change for the better. And I still believe that. But, you know, a lot can happen on the road up to the top of the hill. And I think we are in as dangerous a situation in this country in terms of democracy, and democracy is nonpartisan. We are as dangerous a threat to democracy as we have been in this country, I would say, since the end of the Civil War. Obviously, I teach the 14th Amendment. I'm launching a 14th Amendment Center on Law and Democracy at Howard. And I spend a lot of time in that period and in, you know, the decades thereafter. And I would say we are in a very, very dangerous period of time for this country. And I would say something I've never said before, which is that there is no guarantee that we come out of this period as a democracy. Do I think we ultimately will be one? Yes. But democracy ebbs and flows. And if there's one error that we've made, I think, is in believing that the march is always in one direction. There are continuous loopbacks. and those loopbacks can take time. And so I'm not being flippant when I say I have no doubt about what the end is going to be. I have no doubt that there's so many good, smart, engaged, committed people in this country to the ideas and the ideals of democracy and equality and justice that I have no doubt that we will ultimately prevail. But ultimately can be a long way away. And what we have to fight for now is the in-between time and leave enough energy and optimism to also begin planning for that period when we have a chance to make this country the democracy that we really want it to be.
Yeah, thank you for your bracing candor, Sherilyn. Let's drill into the in-between. So this new administration has taken an array of actions that affect democracy and civil rights, such as on immigration, trans issues, DEI, pardoning the January 6th defendants, as well as dramatic cuts to federal funding and staffing of federal agencies. A lot of observers are having difficulty focusing right now, given the sheer number of activities that are happening under this kind of quote unquote flood the zone strategy.
Yeah.
So which actions stand out to you as particularly pertinent and worth paying attention to? So obviously all of them at some level, but if we're going to prioritize, how would you help us do that?
Gosh, it's really, you just said that and now it just seems really hard. I'm gonna name 4. I'm gonna start with pardoning the January 6th defendants. I think this was really profoundly corrosive and dangerous. Corrosive of the rule of law, an important contribution to the project of trying to memory hold January 6th, an important part of the project of taking hold of reality and bending it to one's will, an actually physically dangerous thing to do for many people. And, you talked about the book I wrote. One of the things about lynching is that the people who perpetrated these crimes did so in the belief that the communities that they were a part of approved, right? They were transgressing the formal legal system, but they thought their neighbors and their neighbors' neighbors approved of what they were doing. And that's why they did it openly. That's why it wasn't hidden, because they felt that they had community approval. And when I see transgressions of law in which the perpetrators believe that they have the support of the communities around them, I think that's some of the most dangerous. Those become some of the most dangerous people, because what most people care about is not some far off legal system. They care what the people in their family, their neighbors, their communities actually think. So I think for the president to have pardoned many of them quite violent individuals, individuals who attacked and beat police officers, which, was supposed to be the verboten thing, and to see it done with nary a word from the very law enforcement organizations that I had to fight against for 10 years in the efforts to try to get policing reform. The same organizations who insisted we could not in any way speak against the police, stand against police violence, stand against police brutality. Colin Kaepernick couldn't take a knee without, violating the profound and important tenets of patriotism and so forth. But to see that happen and to see those same organizations be silent, and it just was very from the height of kind of the rule of law concern right down to like my first thought was about the family members who turned in their family members, right? The kid who said, yeah, that was my dad, right? The ex-spouses who said that was my ex-husband I saw in the video, and just the danger that they must feel and the lack of protection that they must feel from our government, but also making a mockery of the rule of law. So that's one that was huge. I do think that the DEI piece is actually pretty diabolical. And I really now am referring to the airplane crash in Washington, D.C. This was a situation in which it was very apparent that, in my view, the president feared that there would be blowback because he knew what had happened, what the actions that he and his colleague Elon Musk had taken with regard to the FAA. And Trump is always very good about getting out ahead of the potential for blowback. And so he launched right into DEI. And the reason why I think it's so important is because it revealed everything about the kind of bankrupt and corrupt nature of this anti-DEI move, right? You don't need to know whether any of the pilots were Black or women. It doesn't need to make sense any more than when the door fell off the Boeing plane and Elon was the first one who suggested that DEI was the cause, right, of a door falling off of a plane. It doesn't need to be logical. You don't need to prove anything. But what you do is you tap into something that already exists in the psyche of tens of millions of Americans. And that myth of Black incompetence, of women incompetence, exists. This is what I think has been so exploitative and the reason why it has so taken off. It's not just that it is, racist and misogynist and all of those things. It is that it calls and taps into the existing biases that exist in many people, including your and my colleagues, who have views that, about the competence, even when they don't know consciously that they have those feelings. And so I think to see him then take that moment of tragedy, and, as you may know, someone who was about to join my faculty, a lovely young woman, Kia Duggins, was on that flight, a civil rights lawyer. She worked at Civil Rights Corps, and we had just hired her to start in the fall at Howard Law School. This was just incredibly tragic. And to use that moment to advance this DEI narrative was so ugly and so awful. And of course, the executive order itself is kind of horrifying in its language, in its scope, and in its effort to basically transform American life as it exists in every aspect of American life. So that is, really high on the list. The separation of powers issues and with the stand down of Congress as Elon Musk rampages through the federal government is among really truly the most shocking things I have ever seen. And I don't think anybody was trained for it. It would be I mean, we all suffer from a lack of imagination at this point, but not that an individual would want to do that. And not that even the current president would allow an individual to do that, but that an entire branch of government, the leadership of an entire branch of government, the United States Congress, would stand down while their power is literally taken from them and passed to the executive, that they would allow for the gutting of agencies that they stood up, that exist because of Congress's lawmaking, and that they would allow an individual, an untrained, unprepared individual of dubious intention to come in with a group of his own people who are unvetted and destroy what Congress created. That, I think, is among the most frightening and outrageous things that have happened over the last month. And then the last thing I will say is the executive order that decides not to recognize trans people is one we should be paying very serious attention to, not only because of the way it treats trans people and because of the tremendous pain that it causes, but also the danger that the lives of trans people have been in and are in. But because when the federal government decides to disappear a group of people from recognition, that should profoundly concern all of us. That's a pretty awesome power, and used inappropriately, a very dangerous power and a very dangerous precedent to be set. I do think that this particular administration, and I would say, we could talk about whether the Supreme Court is part of this particular project as well, would like to disappear race. I think they would like the French model, where we keep no statistics, right? We keep no information based on race, which we do in this country, precisely to have the data we need to determine whether our constitutional requirement of equal protection is being met, whether our goal of equality, whether our value, whether our identity as a nation that in which justice and equality are core values, whether we are meeting them. And we need that information to know. And I think that's where this administration is headed. And I'm not sure that the Supreme Court's not headed that way too, since they seem to think in the SSFA decision that merely recognizing race is the evil, right? And describing it almost as an evil. I mean, it goes back to John Roberts in the Parents Involved case. The only way to stop racial discrimination is to stop discriminating based on race. But increasingly, it appears that they think that discrimination is the recognition of race itself. So that worries me deeply.
Yeah, I call this sensory deprivation equality, right? In the sense of both colorblindness, forgive the ableist term, and don't ask, don't tell in their respective domains. Pretend that we can make the problem go away, of discrimination go away, if we just don't recognize it all.
Yeah.
It's right up your alley. I've taken to kind of trotting out this district court case about the decennial census from a while back, the Morales versus Daley case, where the judge was like, what are you talking about that you can't ask questions about race on the census? Because how else would we enforce our civil rights laws unless we know? How would we know discrimination is taking
I think they figured that out. Yeah.
The denominator is. So yes, exactly. So, I mean, you talked about how Congress was standing down, and you talked about the Supreme Court. I mean, I think most people, right, that I'm talking to are saying, I get that Congress is not going to provide a meaningful check on this administration. So I'm now going to turn to the courts and file this flurry of legal challenges against administration's executive orders. We saw last Friday, actually, a positive development there, where a district court in Maryland, issued a preliminary injunction to put a pause on at least most aspects of the DEI, anti-DEI order. I'm just wondering, like, what role you expect the courts to play over the next few years, given that we have a 6-3 conservative majority that has not been particularly, to put it gently, receptive to civil rights claims. And also, as an add to that, may I ask, are there any particular cases that you're watching that are pending before the Supreme Court this term that you think our audience would need to know about?
I guess we've gone so beyond what the Supreme Court is going to do because the anticipation of what the Supreme Court might do has become the law. In the DEI space, most of the dismantling that's being done is kind of anticipatory. We know what the Supreme Court held in the SSFA case, the Harvard and the UNC case, and they struck down race-conscious admissions at Harvard and at UNC. The Supreme Court said absolutely nothing about DEI. And in fact, there's no real defining of DEI by this administration or by many people who use the term. So it's very hard to figure out how to interpret the SSFA decision in light of DEI, because it depends on what your definition of DEI is. And conveniently, rhetorically, it can mean almost anything you want it to mean, So it's like woke and it's like CRT, right? Words that had real meaning, but that now have been hijacked and used as a cover, as a sheer over efforts to engage in a particular agenda. And I think most of the reaction to the SSFA decision has been as though the Supreme Court said in no aspect of American life can race be considered. And, and that's not actually what the decision said. And so a part of what troubles me most is we're doing the work for the court. I don't know what the court would say about it at this point. I mean, I'm not wildly optimistic. I can see just as well as anyone, some of the writing on the wall, but I like to wait for the Supreme Court to, tell me to stop doing something before I think I have to stop doing it. And I think this kind of anticipatory compliance with what the Supreme Court might do, right, has really caved DEI in on itself. It has not been the court that has done it. And it was happening before this executive order, with corporations getting nervous and universities getting nervous. And what are they getting nervous about? They're getting nervous about the possibility of what the Supreme Court would do if a case were to make its way to the Supreme Court and the Supreme Court were to decide that these measures were unconstitutional. So I think there's something off about the way we are. Maybe that it's a kind of post-traumatic stress response to what has been a set of truly hellacious Supreme Court terms over the past few years, that it just feels like, oh God, no good news is going to come out of the court, and so therefore let's get out ahead of it. Let's pull the Band-Aid off ourselves. Maybe, but I think it's been very corrosive, and I think it's almost shifted. It's almost like a form of lawmaking, just kind of a consensus that this must not be constitutional. And that seems just awful and terrible and incredibly dangerous to me. What do I think the Supreme Court would or will do? I think the Supreme Court has so much on its hands right now that I feel pretty certain that they would rather not enter this space if they can avoid it. So I would, think about the possibility of some cert denials and I think they would be happy to let this percolate for another couple of years, because they have some doozies headed their way, and it's a lot. And I think that having done what they've done, they want now to be able to be equipped to face these other challenges. And as these challenges become more dangerous, as the narrative of, well, do we have to actually obey federal court decisions becomes part of the conversation. What's the other one? We should impeach judges, that we don't like, or after a year, we should evaluate them and get rid of lifetime tenure. There's a lot of conversation that's coming out of, a lot of it generated by Elon, who is the wealthiest man in the world, is the best buddy of the president of the United States, has cowed Congress because so many fear his threat to primary those who don't go along with him, and because he has a reach. He's talking to 200 million followers 100 times a day. So I think that honestly, this court has bigger fish to fry in terms of being concerned about our entire apparatus of law and judging, and these vital separation of powers issues that I described. Now, they do have coming the birthright citizenship decision, right? So they do have a serious, very direct constitutional question coming their way. And I would say, I wrote a piece a few weeks ago about, what I called the other constitutional crisis. And because the constitutional crisis we most often talk about is usually a separation of powers constitutional crisis, in terms of whether, the executive will obey court orders, or the relationship between Congress and the executive. But I contend in the piece that I wrote that we have been in, a decades-long, and I would say maybe even 100-year-long constitutional crisis of resistance to the 14th Amendment. And we have watched the 14th Amendment be dismantled, undercut, disturbed, ignored, for 100 years. We had a brief period of time when it was revived in Brown versus Board of Education, and in the decades following by the Warren Court, by civil rights activists, by LDF, and other civil rights organizations. But we are kind of back where we were. And we saw it last year in the Section 3 case, where the Supreme Court kind of decided itself to read something into Section 3 that just doesn't exist in the text, doesn't exist in the legislative history, is not apparent from the intention of the framers, and so on and so forth, and decided to just read an extra step, into Section 3 that doesn't exist. And, obviously we saw the Supreme Court strike down race-conscious admissions. We have seen the court, this particular court, be quite hostile to the 14th Amendment. And we've seen prior courts be hostile to the 14th Amendment as well. So that's been a long project. And now you have a frontal challenge to the very first sentence of the 14th Amendment, and this challenge to birthright citizenship. And my gut would tell me that the court would not adopt this administration's position, that the words, so the first line of the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. The purpose of it, we know, was to ensure the full citizenship of Black people, both formerly enslaved and free, and to overturn the Dred Scott decision, which had said that Black people in this country could never be citizens. So it was essential to ensure citizenship. We'd had the 13th Amendment that ended slavery, and now we needed to bring Black people into the fold of citizenship. But we also know that those very same framers, had their own prejudices and expressed their concerns. There were members of Congress, representatives from Connecticut, from California, who were very concerned about the likelihood that if these words became the words of birthright citizenship, it would mean that the children of Chinese laborers were not permitted to become citizens of this country, but that their children born here would be citizens. And there were complaints from representatives in California. Are we going to be overrun by the Chinese? And yet, despite those very concerns, those same legislators voted for this birthright citizenship language, with one even saying, yes, I accept that. And I won't even, you can imagine the slurs that they used, but that, I accept that the children of these laborers will be citizens. So it's not as though what's happening now, where there's this concern by this administration about children of migrants coming from the global South, that was discussed and dealt with. But the Supreme Court 100 years ago in the Wong Kim Ark case, again, the child of Chinese laborers was deemed a citizen, resolved this issue. Now, will the Supreme Court overturn a 100-year-old precedent and reimagine the words of the 14th Amendment in terms of what that sentence meant? There's nothing that stops them from doing it. I want to think that they would not. It would be incredibly destabilizing. And so my sense is probably that they won't, but I could not say with any measure of certainty after the last few years that they would not do. I don't think there are 6 votes for it. Are there 5 votes for it? Maybe, but I tend to think not. What do you think? What do you think, Kenji, actually?
Yeah, I teach Wong Kim Ark alongside Justice Harlan's dissent in Plessy, right?
Yes.
The odd mix of, pro-Black but anti-Asian sentiment, right? Where he says, there's a race unassimilable to our nation, right?
Yes.
That in saying that there shouldn't be birthright citizenship accorded to people of Asian ancestry. So, it's for me, part of the puzzle of the kind of Rubik's Cube that we're trying to solve is how this court thinks about different groups, because we see Justice Alito, for example, in the affirmative action case, kind of rending his garment about the poor plight of the terrible, the poor plight of the Asian American who's subjected to all this awful discrimination. And I'm just sort of looking at him, not him personally, but all of these individuals like Edward Blum or the like, and just wondering, when have you ever expressed any interest in the rights of Asian Americans other than this particular context where Asian Americans are a cat's paw for the interests of the dominant group? So I'm curious to see what they do with this case, because I think it will come, marked as a Latinx case, but I think it will come with tinges of this is an Asian American case as well, with all the kind of invidious resonances.
Oh, I think so. I think so. And I think it's important to really mind that history. I actually think, Kenji, one of the reasons why it's so important, and I'll try to write something, on this shortly, is that that history is what puts paid to the whole concept of colorblindness, which, just sometimes I just, I'm gnashing my teeth, because I think, again, you could just take a word and decide that it is a standard, right? And it is now become, especially when you read the SSFA opinion, it is like the gold standard value, right? And that those who seek to try and honor the spirited intention of the 14th Amendment by engaging in race-conscious admissions and by supporting diversity are engaged in evil. And those who are pursuing this idea of colorblindness, which appears nowhere in the Constitution, are the people who are doing right by our nation. Colorblindness comes from the argument made by Albion Tourget, the attorney in the civil rights attorney, white civil rights attorney from North Carolina, who was incredibly brilliant, but who was litigating the Plessy versus Ferguson case. And it was picked up because Albion Tourget used it by Harlan in his dissent. But as you point out, if you're reading Harlan's dissent, so first of all, since when does a concept that comes out of a dissent become the standard? But, you know, it's a dissent in which Harlan is contradicting himself, right? You know, he says there is no caste here. Our Constitution is colorblind, but there is a race of people so different from our own, right? So why would we be then taking, right, that the concept that he articulates, you know, and we've got like 3 paragraphs of just something that's so contradictory and ugly, and we want to pick out the word that we like and decide now that that is the constitutional standard. It doesn't appear in Brown. So where does it come from? It comes from that dissent. And when you know what that dissent actually says, it makes a mockery of the long conversation about colorblindness that Justice Roberts engages in SSFA, which, if you know that history, is embarrassing because you are relying on something that is premised on sand. So I think it is an opportunity to have that conversation for sure. But I agree with you. I wonder whether they will feel, since they know what the implications are, whether having put themselves out there as the champion of Asian Americans, at least in college admissions, they want to maintain some level of consistency. I don't know. I don't know the answer to that. I don't know how cynical, truly how cynical they are.
Yeah. I'd love to thank you for that. I mean, speaking of, you know, Asian American civil rights, we had the Korematsu lecture here, and Vanita Gupta and Jenny Yang co-delivered it. And they did an unbelievable job. Vanita Gupta, most memorable line for me was, "Hope is a discipline." And Jenny Yang's most memorable line for me was, "Remember that during the first Trump administration was when we saw sort of ordinary citizens sort of taking to the streets for Black Lives Matter or the Me Too movement." And so I wanted to ask you about that, the ordinary citizen in the second Trump administration. There's been a huge amount of media commentary on the decline of the resistance as compared to Trump's first term, when we did see a lot of mass public protests. I mean, Jenny Yang's point was, you know, if you can't rely on your government to do it for you, then you actually take to the streets and you end up doing it yourself. And that's how we got, you know, Black Lives Matter. So I don't know if you agree with that, you know, assessment, but, you know, I think I'm even more interested in this contrast point of, do you see a difference in terms of the intensity of the resistance today from what you saw with regard to effective civil engagement during the first Trump administration?
I mean, it's kind of hilarious, actually. I just completely disagree with the premise that I have read as well, you know, in media outlets, that there's a huge difference and that, you know, there's the resistance levels are muted this time around. So first of all, we are literally a month and a half into the Trump administration. So I'm not sure what, we're not comparing apples and apples, right? Because what folks are doing is they're looking back at a 4-year period. They're thinking about the Muslim ban and all the people going to the airport, all the lawyers, which was fantastic. And they're thinking about the George Floyd protests, which was in 2020. And the other protests that were happening were largely about police violence, and they had been happening since Obama was president. Ferguson happened when Obama was president. Freddie Gray happened when Obama was president. Walter Scott was shot when Obama was president. And so the activism that was happening, that was what you think of as the Black Lives Matter activism, was happening long before Trump got to office. Black Lives Matter was created after the killing of Trayvon Martin, which also happened during President Obama's first term. So the activism that we saw in Trump's first term was activism that had developed before he ever came into office. So I do think those are the 2 counterpoints they're thinking about: Muslim ban, everyone going to the airport, and the George Floyd protests, which didn't really have to do with Trump, to be perfectly honest. It had to do with police violence, and it was the peak of about 7 years of protests that had been happening around police violence. So that's one. But the second thing is, I think there is a tremendous amount of resistance happening, and I actually kind of almost like it better because I think that we tend to think about mass protests as the way that we know that the people are fighting back. And we've been trained to that largely from the civil rights movement. But you know what's great about the George Floyd protests is that they happened in 50 states, all 50 states, and they ended up being the largest civil rights protests this country's ever seen, including outpaced the March on Washington, everything. But they were happening all over the place. It wasn't just one mass protest that everyone went to. And what I'm seeing now, when you see the protests happening around the country, when you see the organic nature of people are making their own decisions about whether they want to protest Tesla, about whether they want to stand outside Treasury, about whether they want to stand outside the GSA, about whether they want to boycott, certain facilities that have or corporations that have abandoned DEI, or people are doing the thing that moves them, and it's quite diverse. And I actually, when I say I feel almost better about that, I think given the consolidation of power now and given the excesses of power that we are seeing, it has never left my mind that when the George Floyd protests were happening, then President Trump was asking his defense secretary, why can't we just shoot the protesters in the legs? I've never forgotten that. And Esper would not do it. And one of the reasons Esper was fired was because he resisted Trump around a number of issues. I don't think Pete Hegseth is the resistor guy to Trump. I think he's all in with Trump. And I don't know how this administration would respond to organized mass protests all happening in one place. I just don't know, especially if the perception was that violence had broken out. And I say perception because it could be violence, it could not be, it could be perceived as violence. So honestly, I think the fact that people are finding many different ways to express their outrage. There are people who have downloaded that app and they're calling their, Congress people every week. There are people who are showing up at town halls in states all over the country. I almost think there's a much more kind of democratic sense to the measure of resistance that we're seeing. And because it's not all in one place, it makes it very hard for the media to see it. When they see a big protest in Washington, D.C., then they know there's resistance, right? If they see a big protest in New York, they know there's resistance. But if they see, people at 6 different town halls and at 1,500 different Tesla plants and how, I don't think that they have the capacity, and I think some lack the imagination to tie all those pieces together to understand what resistance can look like when it is decentralized.
That's fascinating. So it's kind of infinite and infinitesimal, right? And so it evades detection. That's really
Yeah.
I'd like to remind the audience to submit questions using the Q&A button, but I'm going to use my moderator's prerogative to slide one more question in there. We started in this direction, but you're kind of a beacon, not just of civil rights, but I think of hope in America right now. So many people in our community are despondent right now, feeling that supporters of civil rights lack legislative, executive, and judicial power. What forms of power do we still have to advance civil rights and democracy in this country? And what, if anything, gives you hope in this moment?
Yeah, so one thing I think is really important, and, when I led the Legal Defense Fund, one of my goals, in fact, even when I interviewed with the board before I took the job, was that I wanted to move the conception of civil rights away from the edge and into the center of the conversation about democracy. So when we talk about the future of civil rights, we're talking about the future of democracy. And the two are inextricably joined. It's why I think I don't see this country as having a credible claim to being a democracy before 1954 and maybe 65, but certainly 54, when you had half the country living under legal apartheid, that can't be a democracy, right? So the two are inextricably linked. And what gives me hope is that I'm seeing the resilience of people who are trying to keep alive the things that we need to be able to create the just society that we have worked for and dreamed of. I'm actually quite heartened. I just finished a piece for a Substack that I'm part of about, you know, the lawyers who resigned from the DOJ and who upheld their ethical obligations under the model rules of professional conduct and under their state professional rules to not make false statements and representations to courts, that we must have candor when we face a tribunal. And on that basis, we saw 7 lawyers in the Department of Justice choose to resign rather than sign a dismissal motion that they could not ethically put their hearts and their minds behind. And so I'm heartened when I see that. We see across the country that there are a number of lawsuits that have been filed about these various EOs, and they're doing what they're supposed to do. We don't know ultimately what the outcome of those will be, but they are doing what they're supposed to do. They are slowing things down. They are because we're being overwhelmed with the pace and speed. And what happens when you file these claims is that courts need time. They are going to, effectively consider. We're seeing some extraordinary judges who are taking their time. We saw Dale Ho decide to appoint Paul Clements as amicus to, explore this question of that, where you have both the government and Eric Adams, the mayor of New York, seeking to dismiss the charges against him. So we see judges taking the kind of care, the care we don't feel because it's coming at us like, like water out of a fire hose. And so it's doing what it needs to do. It's providing time and space for careful review, for slowing down, for application of the law. It's showing people that courts still play a role. It's resuscitating and reviving the role of the judicial branch in this power grab. And so I think that gives me hope, but it also gives me hope that people, we worry sometimes because we can only see the manifestations of power, but there are tens of millions of American people who believe in the values that this country has attempted to articulate and has fallen short of for sure since the Civil War. And that's why I focus on the 14th Amendment. That, the first place where the concept of equality shows up is in the 14th Amendment. And it's that second constitution that shapes our expectations of this country. And I think most Americans believe that that is the way this country is supposed to operate. And every time someone asks, what should we be doing? It makes me feel better because people are aware that they should be doing something. And to the extent there was apathy before, to the extent people thought, I gave the commencement address at NYU in 2013. And I talked about us being civil rights lawyers being democracy workers. And I said at that time in that commencement address that we were at a point in our country where we needed everyone, we needed all lawyers especially, but everyone to feel like they are democracy workers, to feel like they have to do something, that democracy doesn't just sit there on the table and then just last forever, that every citizen has a role to play, every institution has a role to play. And as terrible as things feel right now, and they do feel terrible, I do think that more Americans than ever before in my sentient lifetime have awakened to the idea that there are things they're supposed to be doing in order to hold and preserve and strengthen our democracy and make our democracy healthy. And that's the platform on which we can build the country that I think many of us have all dreamed of.
Thank you for that. I'm now going to turn to the questions from the audience. And the first one is, on the topic of democracy ultimately prevailing, I also strive for optimism, but I worry that the current age of misinformation and information overload adds a new element that is hard to overcome. How do we organize common interests in the way that you just described in protecting civil rights when some voters are in an alternate reality?
Yeah, I think you reach who you can reach. People always say to me like, but how are you going to talk to the person who, believes this and only, lives in a QAnon world? I'm not going to reach that person. And I don't think I have to try to reach that person. I think that what you have to try to do is reach the reachable. And we're being challenged to find new ways of connecting with each other. We're being challenged, just as we're being challenged to keep informed and find ways of finding reliable media as mainstream media begins to collapse in on itself. So yes, it's an incredibly challenging time, but we will find a way. We have to find a way. We talk in my community all the time about how we're going to keep our children educated about our history as school districts are shutting it down. We're going to find a way because that's what we have to do. But I don't disagree with you that the internet misinformation and the social media manipulation and the collapse of mainstream media, some of it self-inflicted, is one of the grave challenges that we face, the acceleration of misinformation. But I don't kid myself that misinformation is something new. I just was having this conversation with tech folks at a conference on Monday about the misinformation during the civil rights movement. There were people who genuinely believed that Martin Luther King was a communist, that, he and civil rights workers were working with Russia, right? And it created an incredibly dangerous environment, partly the environment that ended in his assassination. It wasn't just that people were racist, they were, but they also were being fed a steady diet of what the civil rights movement was about, what the goals were, who the people were, what they represented. So we've been dealing with misinformation for a very long time. The acceleration is off the charts. The intentionality of it from the highest levels is off the charts for sure. But I think that's the challenge that we have to face. We can't throw up our hands and just say, we can't compete. We can't compete on that platform. We can't compete in their way, right? I'm not going to tweet as much as Elon, and I'm not going to tweet because I'm not on Twitter anymore. But we are finding alternative ways of communicating with each other. And I'm very heartened when I see people sharing different media outlets that allow them to keep up with what is really happening and adding new voices and perspectives. Really excited about some of the nonprofit media that has really developed and is doing such an incredible job. We are going to have to navigate a way to get around those things that ultimately have been hijacked. Hijacked suggested it was, with us, and then again, well, hijacked in any case, and are largely carrying forward kind of anti-democratic values.
Yeah, when you say hijacked, I'm reminded of my another person I hugely admire, Mary Bonato, who says, I hate the word backlash because it's just we did something wrong, whereas I've just experienced anti-LGBT stuff as lash. Like, this isn't backlash.
That's right. That's right. That's a good point. Oh, yeah. I love Mary. She's great. That's really good point.
Yeah. So another question from the audience. This one hits, I'm afraid, quite close to home for me. What, if anything, does it say that some of the highest officials complicit in promoting the current administration's agenda, from the vice president to Supreme Court officials to heads of agencies, are graduates of our finest law schools? What, if anything, does it say about legal education in this country?
Nothing good. I joined a task force, an ABA task force on democracy, in part for this reason. At the end of in 2018, I wrote a piece, or maybe it was 17, I wrote a piece in the Washington Post about the role of lawyers in some of the excesses of the first Trump administration. And it disturbs me greatly. And the reason it disturbs me is because there is no healthy democracy without a healthy legal system and the rule of law. You can't name a healthy democracy in the world that doesn't have those things going for it. And the degradation of our profession is, to me, an attack on democracy. And so lawyers who have participated in degrading our profession, a democracy has all kinds of backstops. Some are law. That's a biggie for sure. Some are, norms. Some are ethics, right? The ethics of professions are important, and certainly of the legal profession, because it means that we have kept a system in which, despite all of its flaws, and our legal system has many, there is a premise of conduct between the lawyers who participate in it. And somehow that is missing. I'm not sure that lawyers understand and are being taught about what democracy means and about what our obligations are to democracy. I've been talking about it from a 14th Amendment perspective, for sure. Lawyers are licensed by their state bars, and they have obligations to democracy as well. And I don't think that we're teaching our law students enough about the history of this country, about understanding why these principles were created and the way in which they knit together with the fundamental tenets of democracy. I have to say, I am astonished by how little most lawyers know about the 14th Amendment. I don't think most lawyers, in fact, I would suspect most members of the United States Supreme Court had never studied or read the full 14th Amendment, and certainly had not read Section 3 before the cases began to percolate through the system last year. So we are doing a poor job. And again, I would just say, Eric Foner calls the 14th Amendment the most important addition to the Constitution since the Bill of Rights in 1791. And yet we do an incredibly terrible job of educating law students about the way in which the 14th Amendment was designed to actually change the balance of power between federal and state governments, to advance this idea of equality, this recognition of the ongoing reality of white supremacy and trying to protect against it, this recognition of the ongoing spirit of insurrection that they believed existed in the country. All of those things are not part of legal education at this moment. And one of the things I'm trying to push with my center is to have, every law school should have a 14th Amendment seminar, just like they have a First Amendment seminar. But judges lack this information. And so, yes, I do believe that what we have seen is an opportunity, is a call for our nation's, believed to be best law schools to take a look inward at what they are producing. It's not about whether you're producing people who are conservative or people who are liberal. Part of the reason why the legal profession is so important is that our ethical obligations are not partisan. They do not depend on our partisan affiliation. They are independent. And seeing the resignation, for example, of the attorneys at the DOJ a few weeks ago was kind of important, because Ms. Sasson, the lead attorney, the senior attorney for the Southern District of New York, was really important because she is a dyed-in-the-wool conservative, former Scalia clerks, former J. Harvey Wilkinson clerk, and she would not sign that motion that her supervisor wanted her to sign because she could not stand behind it. It had nothing to do with her partisan affiliation. She was in the job she wanted to be in, but her ethical obligation to speak with candor to the tribunal made it impossible for her to sign that motion. And that's why our ethical obligations as lawyers is a backstop against the kind of extremism that threatens democracy and that threatens the rule of law. And somehow along the way, that lesson is not happening. And so one of the things I think needs to happen, and that we're talking about in the ABA, is we need to have mandatory CLE, democracy CLE for lawyers. That, because many of these people are not fresh spanking new lawyers, and they weren't in the first Trump administration either. We need to refresh our understanding of what our obligations are as lawyers, of what democracy is, of where we step, the role the law plays in a democracy, and what the expectations are of us. And that needs to be refreshed throughout our profession. It does not matter how elevated your client is. You have obligations. You may have seen last week, unrelated to the Department of Justice, but one of the attorneys, a quite respected criminal defense attorney in New York, Anthony Rico, withdrew from his representation on the team that's representing Sean Diddy Combs. And, he said, under no circumstances can I continue this representation in accordance with, the ABA's rules on criminal justice, right? I don't know, and he said the matters relate to attorney-client privilege, and so he has to be brief in his affidavit, So he's not revealing anything, and I don't purport to know what it is, but, this is staying with that representation, I'm sure it could be lucrative. But whatever happened, something happened, and he had been on the case, and they were, close and friends, but whatever happened within the context of that attorney-client communication compelled that attorney to say, I cannot continue this representation. That's what holding to your ethical standards means. And it doesn't have anything to do with whether you like your client, whether your client is the richest man in the world, whether your client is the president of the United States, whether your client is, a disgruntled a member of a bowling club, right? It doesn't matter. And so, yes, it concerns me particularly concerns me when I see lawyers behaving in this way. We can remember a few years ago in that voting rights case that the then Kansas, I want to say Attorney General, but he may have been Secretary of State, Chris Kobach was advancing, and he had to be sanctioned, by the judge to like take a civil procedure course. What is going on? Because people are playing fast and loose with the rules. So I think, yes, I'm deeply concerned, and I think it's very important that legal education see that the red lights are flashing. Something's missing.
Thank you for that. I'm afraid this is going to have to be our last question, but I think it's a really good one because we have talked about sort of alternative avenues of hope, and mostly we've been focusing, I think, at least in my mind, on the separation of powers issues of which kind of department to go to. But this question is a federalism question. In light of the situation at the federal level, are there any efforts to expand civil rights at the state level that are particularly exciting and promising to you?
Thanks for that question. We always talk about, I will say I've long been a bit of a skeptic, but only in this way. And there have been, you've seen various states pass their own voting rights acts in New York and Michigan, other places. And I think that's very exciting and important. But because I've been a civil rights lawyer for, 35 years, and the 90% of my clients, have been African Americans who live mostly in the South. 52% of Black people still live in the South. And many of them live in states that are where the legislatures are quite hostile and the governor is quite hostile to civil rights. And so when we talk about doing things at the state level, which states are we talking about? Let's be really real. Because if we're talking about where most Black people live, it's kind of a non-starter. The state that has the, I always stump people with this. The state that has the highest number of Black people in it of any state, right? Mississippi has the highest percentage of Black people, it's nearly 40%, along with, in the 30s is South Carolina, is Maryland, a number of those states in the Deep South, right, have Black population somewhere around 30%, which is a lot, which you would think would have an opportunity to influence the outcome of elections. And it should tell you something about the fact that they don't. But the state that has the most Black people numerically is Texas. So if you looked at all of the states and their Black populations, the largest number of Black people would be in the state of Texas. And there's a lot going on in Texas. So when we talk about whether the states are an avenue, I have to ask what states, because we can make ourselves feel good about California and New York and Illinois and New Jersey and Connecticut. But for my work, it's not getting to the nub of the problem. And I think one of the problems that we've had in this country is that we have been willing to leave to, we've been willing to accept the idea that there are parts of the country that work in an anti-democratic way down there. Well, now we can see that if we're going to be a country, we cannot accept that down there because it will metastasize. And there are many of us who have been saying that for years. So those who ignored what was happening in states like Arkansas and Alabama and Mississippi, now we all live there, And so many of the forms of conduct, many of the forms of oppression and so forth have metastasized across the country. So I think when we talk about solutions and things that we can do at the state level, for the most part, we're talking about, a handful of states where we think we can make real progress. But I'm never going to be satisfied leaving to their own devices the people who live, in the states that we would think of as the former Confederacy or the red states or however you want to refer to them. For me, they're the states where most Black people live.
Yeah, which is really the impetus behind the 14th Amendment, right? As you say, that's why you lead a center on the 14th Amendment. Sherrilyn Ifill, thank you so much for spending this time with us. I always leave every conversation edified, freshly inspired, and frankly, wanting to be a better human. So thank you for all you are and do.
Thank you for having me. I really appreciate it. Take good care.
We're adjourned. Thank you all so much.